We will hear argument first this morning in case 24-557, Villarreal versus Texas. Mr. Banner. Mr. Chief Justice, and may it please the court, during an overnight recess, the defendant and his counsel have a lot that they need to talk about. They need to go over the testimony that took place that day. They need to prepare for the testimony that's going to be given the next day. These are basic discussions that any competent lawyer would have with his or her client. This is the assistance of counsel that the Sixth Amendment of the Bill of Rights of the U.S. Constitution of these United States of America guarantees. But the defendant and counsel can't have these conversations if they're not allowed to discuss the defendant's testimony. For example, if the defendant's testimony has gone poorly, counsel may need to advise the defendant to accept a plea agreement, but counsel can't do that. Not without discussing the defendant's testimony. The defendant needs advice about how to testify without violating the trial court's evidentiary rulings, but counsel can't give this necessary advice without discussing the defendant's testimony. Counsel has an obligation to prevent the defendant from committing perjury, but that'd be impossible without discussing the defendant's testimony. Our brief has many more examples, but the point is that the defendant and counsel often must discuss the defendant's testimony during an overnight recess. Now, the court below tried to distinguish between discussions of trial strategy, which it allowed, and discussions of testimony, which it prohibited, but that's no line at all. It's often impossible to discuss trial strategy without discussing testimony, and responsible defense lawyers worried about being held in contempt for crossing this invisible line will be chilled from offering the assistance that the defendant needs and that the Sixth Amendment guarantees. The only conceivable rationale for restricting overnight discussion between defendant and counsel is to prevent impermissible coaching, but as the court explained in Getters, there are other ways to prevent coaching. There's no need to prohibit the defendant and counsel from discussing the defendant's testimony. I invite the court's questions. Bring it on. Bring it on. What do you got? In the judge's instructions, it says blah, 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 blah. So the Court of Criminal Appeals Justice, so it would violate the Sixth Amendment if it would. No, what I'm talking about is why is the standard different between what a lawyer can coach or manage with respect to testimony while he's on the stand, which is basically a concern, and what he can coach or manage during the recess? No, it's the same. The distinction, let's be clear about the distinction between impermissible coaching and legitimate necessary counseling, right? Because that's a sharp line, and in answer to your question, that line is the same at all times during the proceeding. That is, whatever is impermissible before trial begins is also impermissible during an overnight recess. It's impermissible at any time. Let's just talk about what the difference is, okay? Shit! Can I follow up on counsel if you, yes, I'm looking at page 14 after, yes, when the trial picks up, isn't that a real problem with respect to the attorney-client privilege? What is the prosecutor going to say? Okay, you had a break, you spent the evening with counsel, what did you talk about? Objection, Your Honor, attorney-client. I don't see how that could a reasonable counterweight to the problem. I understand what you're saying. The attorney-client privilege has never been understood to insulate a defendant or any witness from being cross-examined about the extent of impermissible coaching. So the dialogue would go, well, didn't your lawyer tell you to say that? No, he didn't. Or yes, he did. Well, what did? Or something like that. Well, what did he tell you to say? You say, didn't your lawyer tell you to say that or whatever? And he says, no. He said, well, what did he tell you to say or what did he tell you to change? The court in Getters said we're merely following that the way to deter impermissible coaching is for the prosecutor to cross-examine the defendant about it. Now, you're right. You're right that to say that functionally it seems like it might raise the same sorts of privilege problems as having the court ask it, but that's what the court said in Getters, and not just Getters, subsequent cases as well, that the two appropriate ways to deter impermissible coaching, one is cross-examination by opposing counsel, And the other is just for the trial court to manage the schedule appropriately, do some, give some foresight to how long the defendant's testimony but counts. So I guess I don't understand why you're so focused on impermissible coaching as you have defined it. You say here and you say in your briefs that impermissible coaching is where the lawyer is trying to get the witness to change his testimony or whatnot, and that was impermissible, but before and after and during, right, that's all fine, right. That is not what I understood to be the concern here. Going back to Justice Thomas's point, the management of testimony, the talking with the witness about his answers and what some people would call coaching, prepping your witness can occur beforehand, right? Right, that's right, but it can't occur while the witness is on the stand. So Justice Thomas, I think, is pointing to a critical point, which is to the extent that the lawyer couldn't manage, coach, prep, practice with the witness while he's on the stand, why should he be allowed to do so during an overnight recess? This is straight out of Perry, So the court in Perry said that during a brief daytime recess, the trial court can prevent all contact between the defendant and counsel. Understand? Yeah, I'm focusing on the content of the crime. Yeah, no, I understand, right? So Perry doesn't help us with that because because it does. I'm getting to So the court said that after explaining all that for a brief daytime recess, the court then in the next section, in section 3 of Perry, the court says, well, overnight recesses are completely different. The court says, admittedly, the line between the facts of Getters, that's an overnight recess, and the facts of this case is a thin one. It is, however, a line of constitutional dimension. The court goes on to say, during an overnight recess, it is the defendant's right to unrestricted access to his lawyer for advice on a variety of trial-related matters that's controlling, and here is the key sentence. The fact that such discussions will inevitably include some consideration of the defendant's ongoing testimony does not compromise that basic right. Right, so that's precisely what I'm getting at. Yeah, I think there might be, and I want you to help me with this, a difference between discussions that take into account the testimony, maybe even the fact of the testimony, and something that one could call managing right, or prepping right, or the kind of thing that you even admitted a lawyer does right, legitimately to help his client before he takes the stand right. And what I understood the trial court here to be doing was just eliminating that very narrow category of conduct that a lawyer engages in to actually prepare his witness with respect to particular questions and answers on something. And that's the line the Court of Criminal Appeals tried to draw right between. Oh my gosh. Let the fucking lawyer talk to the goddamn defendant, like fucking shit. Hell, if they want to coach him, fucking coach him. Won't that be fucking crystal clear? Well, I was standing there. No, my lawyer says I was sitting there, standing over there. I was kneeling with one. I was partially standing, partially sitting. Don't that just sound like a lie?